Thank you, Professor Buckles. It's great to be here. You were kind enough to mention that I am a native Texan, and while I left the great state of Texas, growing up in San Antonio, born in North Texas, spent a few years in East Texas, then in the third grade to San Antonio, still almost every summer I spent some considerable time here in Houston because of many relatives in the Houston area, including my dear sister who lives in Kingwood. So this is, in its own way, home, away from home for me. The whole Houston area is very meaningful to me, and indeed my sibling, my sister, graduated from the University of Houston once upon a time before she entered her career as an elementary school teacher, called to serve. So thank you for that very kind introduction. Religion in the public square, the future of religious liberty. Where are we going as a society in terms of liberty values, including those of faith, of the voices of faith, especially in a pluralistic society where there are many voices. There are competitions afoot in the public square to get the attention of we the people and to invite us into the conversation. And so let's begin our reflections before we open it up to the conversation, which is going to be much more interesting for all of us, with the soaring words of the First Amendment. Congress shall make no law abridging. So let's make sure that we've got it exactly right. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Then there's a semicolon. So we know that's to stop. Or abridging the freedom of speech or of the press. I'm leaving out commas. We've come to another semicolon. Or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, what we have seen in recent days, on the 2nd of March, in fact, of this month, was what I view as the triumph, yet again, of the Holmesian vision of the First Amendment. And it occurred in a very disquieting context of the funeral of a, call him what you will, martyr, patriot, or call him something that Fred Phelps and folks from a small, unconnected church in Kansas called him. I'm not going to lift up those names. They're very ugly names. They're wretched names. They're dehumanizing names. And yet, the Holmesian vision of allowing this kind of speech to occur, unmolested by government forces, carried the day 8-1. We'll meditate briefly in just a few minutes on the one. But look at the irony in First Amendment jurisprudence that what were once solitary dissents by Holmes, then joined by Brandeis, lifting up the value of freedom of speech, including very controversial speech, because uncontroversial speech doesn't require protection. No one cares. It's only controversial speech and unpleasant speech that even enters the cauldron of litigation. This is the most ardently pro-First Amendment free speech court, and I'll relate that to religious liberty, in the court's history. Not everyone will agree with that proposition and will cite contrary examples, and perhaps we can talk about that in the Q&A session. But that's my thesis. It's the most ardently pro-free speech court in the nation's history. And why is that so? Because even with the famous 5-4 divide and Justice Kennedy in the middle, and he cast the... No, this is 8-1, friends, in this set of factual circumstances that I'm going to put before you. I think, and my thesis is, that this pro-free speech dimension of the court's jurisprudence represents the confluence, sort of like a river bringing different bodies together, of creeks and streams flowing into it. And those creeks and streams that flow into it include the very strong textualist impulse of many members of what does the text say? You just heard the text. Congress shall make no law, as applied obviously to the states in the 14th Amendment. And then the policies underlying the text. What's the text seeking to achieve? What's the goal? What was in the mind of the framers and the ratifiers of the great Bill of Rights, those soaring freedoms that cause us all to say, that's right, that's good. Those are foundational freedoms that we should cherish and give thanks for, if we're people of faith in particular. Let us give thanks and praise that we live in a country that has for now over 2 centuries lifted up these foundational freedoms and has been very serious about it through an independent judiciary that at its best stands up for freedom. That the baseline is liberty. And if government wants to intrude on one's liberty, government needs to come forward with a justification. And especially if it's one of these foundational freedoms in the Bill of Rights, you better have a very good reason, government, for intruding into the baseline and trying to change the baseline. The commitment to a very powerful vision of government by we the people, what we call liberal democracy. And at the core of a liberal democracy that has expanded the franchise, including through the shedding of blood in the Civil War, but then through political reforms, the embrace of women for the last century. Of course, Mrs. Lincoln didn't have the right to vote. Mrs. Washington didn't have the right to vote. Mrs. Madison didn't have the right to vote. As brilliant, perhaps, as those women were, they didn't have the right to vote. So through political reform, and of course the expansion of the franchise through the Civil Rights Movement, including the Voting Rights Act, to perfect this union. The commitment as well, though, to human dignity. It's not just let's participate in a political process, but also think of First Amendment values and how far-reaching those values are in protecting art and expression, because that is an expression of our humanity. And thus art is protected, presumptively protected. Oh, you said, well, aren't there categorical exceptions to the First Amendment? Yes, and that's what brings us together for this reflection before the conversation. I think this is captured to a very great extent in Justice Breyer's very helpful book called Active Liberty. He has a new one out, but his idea of how do we look at the text and how do we meditate on the text. We begin with the text. Let us not think that this is just, oh, what is this? It's a piece of paper. No, this is the text that we take very seriously, and we meditate on the text. And the court meditates on the First Amendment, including the religion clauses, including the freedom of speech clauses. In his book, Active Liberty, he suggests a way of meditating on the text, a perspective, and that is, how do we foster and encourage and deepen the commitment to liberal democracy? To encourage all persons in the polity to be involved. Think now of what's unfolding in the Middle East. Not so much Libya with the horrible violence there, but think in particular of the powerful examples, not only during your lifetime, during this calendar year in Tunisia and Egypt. Astonishing, thanks to social networking, a story that we will be telling for some time. And now the test. Do we care about human dignity? March 2nd, 2011. Egypt has moved by this time, and the court has had sub judice and then issues its opinion 8-1 in Snyder versus Phelps. Fred Phelps, founder of a independent church, has scandalized the nation for 20 years with a handful of relatives. They're all relatives. Fred Phelps and his followers, among other things, picket military funerals. Their message, if you saw press accounts, and if you haven't had occasion to look at the opinion, is one of outspoken, vitriolic condemnation. And I could use even stronger language, as the court does and Justice Alito does in his solitary dissent. Just so we all have a common factual base, let me not characterize, let me go to the court's opinion. For the past 20 years, the congregation of the Westboro Baptist Church has picketed military funerals to communicate its belief that God hates the United States for its tolerance of homosexuality, particularly in America's military, The church's picketing has also condemned the Catholic Church for scandals involving its clergy. Fred Phelps, who founded the church, and 6 Westboro Baptist parishioners, all relatives of Phelps, traveled to Maryland to picket the funeral of Marine Lance Corporal Matthew Snyder, killed in Iraq in the line of duty. The picketing took place on public land, approximately 1,000 feet from the church where the funeral was held, in accordance with guidance from local law enforcement officers. The picketers peacefully displayed their signs, stating, for example, "Thank God for dead soldiers." It gets perhaps even worse, and so I'm not going to read any further. You get the idea. For about 30 minutes before the funeral began, these posters began, and you probably saw television coverage of it. Matthew Snyder's father, so it's Snyder versus Phelps, saw the tops of picketers' signs while driving to the funeral. He did not learn what was on the signs until watching a news broadcast later that evening. Held. The First Amendment shields Westboro from tort liability for its picketing in this case. And so for those of you who are interested in First Amendment doctrine, or you may even have a con law exam, my guidance, study this case. Who knows what might be on your exam in another month. But the Free Speech Clause, now think about this. What is the Freedom of Speech Clause doing here? It is preempting state law. State law protects our human reputations, and it doesn't just protect us from torts of negligence. Thank goodness it does. It's not just strict liability and products liability. It protects our reputations. The law of defamation has been woven over centuries and then modified by virtue of the demands as perceived by this pro-free speech court of the First Amendment to say, aha, if you're a public figure or a public official, first New York Times versus Sullivan, then a public figure, Jerry Falwell, don't come into court and seek vindication of your reputation unless you've got an incredibly strong actual malice, that whole body of law. It's very powerful. It gives a lot of what Justice Brennan rightly called breathing room to the First Amendment, that we should not have, as in the mother country, where libel suits are pretty common, pretty typical in England. So we think England's the land of the free. Well, that's right, but there's no First Amendment. And so defamation cases, libel cases are fairly common in England, with judgments, monetary judgments of some significance, not in the United States. Now this, of course, was not an action for defamation. It was an action for what? The intentional infliction of emotional distress. I'm going to skip over First Amendment doctrine, but just conclude with the description of the case before going to Justice Alito's dissent by quoting the closing paragraph from Chief Justice Roberts' opinion for, again, 8 members of the court. Speech is powerful. It can stir people to action, move them to tears of both joy and sorrow, and, as it did here it is, inflict great pain. The court had its eyes open. It knew this was painful to the lieutenant corporal's father and family. On the facts before us, we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech on public issues, to ensure, it's an insurance, that we do not stifle public debate. That choice requires that we shield Westboro from tort liability for its picketing in this case. Now, we see that something very important is being lost, is being supplanted. A very elaborate body of law that has grown up to protect us, not just from getting run over by a negligent driver, but to protect us from the intentional tort, infliction of emotional distress. Think of how evil that is. How horrible that is. I'm going to intentionally inflict emotional distress. You said, well, perhaps it's because that's so ambiguous. Well, consider this. Under Maryland law, which simply reflects the Restatement Second of Torts, here is, and this is, I'm now drawing from Justice Alito's opinion, to recover, a plaintiff must show that the conduct at issue caused harm that was truly severe. And then quoting, recovery will be meted out sparingly, its balm reserved for those wounds that are truly severe and incapable of healing themselves. Drawing from another Maryland case. The distress that is caused must be so severe that no reasonable person could be expected to endure it. Pretty strong. You hurt my feelings doesn't even come close. Dismissed. You won't make it to the jury on that one. A plaintiff must establish that the defendant's conduct was, now this is Maryland law, this all happened in Maryland as a tort suit in Maryland, so think of your conflict of laws, so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency, and to be regarded as atrocious and utterly intolerable in a civilized community. Friends, that's from the Restatement Second of Torts. And yet, 8-1, the Supreme Court has said, we must allow that, not as to a public figure or to a public official, but as to a private figure. You see, you probably are private figures. And the law is solicitous of your needs for privacy and your reputation. Well, I left out one element in trying to describe what it is that is animating the court, but I left it out intentionally. Why, in light of that daunting standard for recovery, would the Supreme Court turn its back and preempt state tort law that seems so narrow, especially when, this is very important, in the litigation at the Supreme Court level, Fred Phelps said, I concede. We inflicted that kind of emotional distress. So outrageous as to be intolerable. I conceded. But the First Amendment protects it. Because I had a message about the United States, military, a particular Christian community, and I'm at liberty, and my colleagues, to make our views known. Well, one of the reasons, I believe, is an antipathy toward our jury system and toward litigation more generally that shared across ideological lines. I refer you to page 12 of the slip opinion. Distrust of jurors to handle the law. I've given you the law. I have faithfully quoted from the law. But a distrust of juries. This isn't 4 members of the court or 5, it's 8. Now, in light of what we have learned, consider religious voice. You say, well, gee, wasn't that a local church? Yes, it was, but it's not the kind of religious speech that we're accustomed to. The United States Court for the Fifth Circuit is going to be hearing argument in bank in about a month and a half in a very interesting case coming out of a special setting, to be sure, and that's the public schools and speech by students. But it happens to be religious type speech. And so we will see what the Fifth Circuit says in the context of, can school officials keep out of the public schools religious speech? Let me draw from United States Circuit Judge Jennifer Elrod, whose chambers are right here in Houston, and her opinion for the panel. in the case of Morgan versus Swanson. Each elementary school classroom in the Plano Independent School District hosts a winter break and a party during this winter break party at which students, if they choose, may exchange goodie bags containing gifts. Sounds pretty sweet. At the December winter break party at a particular elementary school, a particular student gave each of her classmates a goodie bag containing, among other items, a pencil inscribed with the phrase, "Jesus is the reason for the season." Each gift bag was sealed and had a sticker affixed to it which addressed the bag to a specific student in McKella's class. But before allowing McKella to distribute the goodie bags containing the pencils, school officials searched her gift bags in order to determine whether they contained any religious material. Upon discovering the pencils, Plano Independent School District officials confiscated the pencils and banned them from the school property. Fred Phelps, the little child in Plano. The principal at the elementary school called the student's mother to inform her of the school's action and to explain that candy canes in the goodie bags were acceptable gifts, but that the pencils were unacceptable because they were inscribed with a religious message. The fact, there were a series of these events. One of my favorite, footnote 3, the second amended original complaint alleges that school officials and Plano ISD banned all references to and symbols of the Christian religion and its celebration of the Christian religious holiday, Christmas, from the schools. This ban included red and green Christmas colors. Pretty comprehensive ban in Plano. Bailey Wade was also instructed not to write on Merry Christmas on greeting cards sent to United States soldiers serving overseas, because that might be offensive. Think of Fred Phelps. Think of the little child. So what's going on here? We've got the Holmesian robust, and then all of a sudden, and I could use other examples, but I use one because this is a Fifth Circuit opinion coming right out of Houston, right here, out down on Rusk Avenue, not too terribly far from here. Having heard a case coming out of Dallas saying, kids, we don't want you doing this. What's up? Why the antipathy toward at least certain kinds of religious speech? Fred Phelps might say, I've got a theological worldview. You can agree or disagree, and I'm just speaking in the public square. And you say, well, wait, elementary school kids, is that different? Well, of course it is, but tinker, right? You don't check your rights at the schoolhouse gate. So don't say you don't have any rights as a school child. Of course you have rights as a school child. So let's concede that the setting is different. It's on public property and so forth. But then consider the whole body of case law that we don't have time to discuss, but including a case that you have commented on called Lamb's Chapel. Here's a little organization, a little evangelical church out on Long Island that simply wants to show Jim Dobson films at the local, call it City Hall, but public property. And even though the public property, this kind of gathering place, would be open to, the record showed, Planned Parenthood to talk about family and family planning, it was closed to Lamb's Chapel because why? Well, Planned Parenthood doesn't give you a religious voice, but you're Lamb's Chapel. You've got a religious voice. We've got to keep you out. Supreme Court of the United States, 9-0 in favor of free speech. Now, how do we, and let's move into the conversation, how do we think through this conceptually? First and foremost, as citizens who are trained in the law and who will be called upon, even if you never have a case involving this kind of issue, and you probably won't. But these kinds of issues continue to occur, and your neighbors are going to want to talk about it, and you'll talk about it around the water cooler with people with whom you're practicing law, or even just around the supper table. Here's a simple word, and I hope you'll take it as a takeaway. It's an organizing principle that gets us a long way toward, as it were, an exit ramp off of this huge controversy. and brings us to, as we have here in the great state of Texas, great resting spots. You can pull off this busy highway and find a resting place, maybe even a picnic table. Enjoy the bluebonnets. It's called equality. We fought a civil war about that. Our Declaration of Independence lifts up equality. We like it. It intuitively appeals to every culture that stands in the Jewish and Christian traditions, and perhaps in others as well. But what we know in the West is that Western civilization is built on the idea of human dignity of each and every person. Each and every person, and this can come from a theological perspective, but it comes from our organizing principles together in community, is you're important and you get to vote equally. Well, wait a second. I'm Boone Pickens. Boone's going to be at Baylor in about 3 hours, and I plan to be there. So I'm going to cut this off at 1 o'clock. Boone might say, look, I have made zillions upon zillions of dollars. I've given away approximately $1 billion in philanthropy. My latest is in Dallas. See that YMCA? I built it. My vote should not count the same. Corbin is yours, or stars. We said that's absolutely inadmissible, because no matter how humble and uneducated or undereducated the individual is, her vote, his vote counts the same as Boone Pickens. Why? That's the Western tradition, and that's, I think, what's happening in the Middle East right now. There are voices being raised and saying, here are rules for you, and the culture. Here are rules for some people. And you hear this. When you travel, as I've traveled a lot internationally, the rules don't apply to everybody. One of the great soaring achievements of Western civilization is, at its best, every society has deep flaws. Reform is constantly needed. But the guiding and organizing principle is every single person counts and counts equally, and there it is, the voice. Don't exclude Martin Luther King Jr. from the public square because his voice is informed by Christianity. Don't exclude Muhammad Yunus, Nobel Peace Prize winner in 2006, because his voice is informed by his view of Islam. I could go on with examples, you get the idea. Treat everyone the same. It's the great golden rule of constitutional law. So don't discriminate against Lamb's Chapel. Don't discriminate against the little child who, instead of saying on the pencil, Happy Holidays, says Jesus is the reason for the season. And you know what? If we would all just embrace the equality principle, we'd all be a lot happier, and there'd be a lot less litigation. Thank you for listening. Look forward to your questions.